Goeienaand, good evening, fellow South Africans. And this is a shout out to Lynn. Thank you, Lynn. Really good information. Did you know that expropriation of land without compensation had already been put into a local law called the Property Valuation Act? I'll tell you a bit more about it, just so you understand what's going on behind the scenes. Now, this applies to all property, residential, flats, anything, you name it, and farmlands, of course. Although many, perhaps most ordinary South Africans are unaware of it, a major stride has already been taken towards a regime of expropriation without compensation style latitude for the government. At the end of November 2018, while the country was preoccupied with the debate around whether or not the Bill of Rights should be amended, a set of regulations was gazetted under the Property Valuation Act of 2014. They laid out the formula to be followed for determining compensation payable when a property is targeted for a land reform. The regulations, which are already operational, are complex and introduce a number of concepts hitherto unknown in South African law. In broad terms, they require a consideration of the market value, with adjustments made depending on whether or not a movable property is included, together with its current use value. The latter, which seems to be a nod to the constitutional demand that expropriation takes into account of the current use of the property, is defined as follows. The next present value, as of the date of valuation, of cash inflows and outflows or other benefits and costs that the subject property generates for the specific owner in perpetuity, or, in the case of a lease, to lease expiry under lawful use, and without regard to its highest and best use or the monetary amount that might be realized upon its sale. Now, that sounds terribly complex. But in other words, determining the value assigned to a targeted property hinge on whether or not it is generating an income. But even when this is the case, say when it is a farm or a workshop or a house renting a garden cottage, it seems clear that it's not the income over a sustained period that is up for consideration, but what took place on the day of valuation. So if you've got a farm and you currently don't have crops in the ground, then that's worth diddly squat in this equation. Once these sums have been put together, the resulting figure is divided by 2. In other words, half of what the valuer determines a property to be worth is the starting point for compensation. There is no justification or explanation put forward in the regulations for doing this. It is simply a discount granted to the state and a cost imposed on the owner. Once this has been done, a further deduction is made for any acquisition benefits that might be relevant. These refer to any advantage the owner may have gained by acquiring the property at less than market value, and with the benefit of discriminatory laws. Where this is the case, the amount of such benefit must be escalated to the valuation date using an appropriate cost of price index. While 30 days is accorded for representations against the valuation reached, the Valuer General is required to do no more than consider them. As my colleague Dr. Antia Jeffrey has remarked, under the formula laid down in the regulations, the value of property targeted for land reform will generally be about half of the market value. Sometimes that value will be 0. There is much here to concern ordinary people. Based on the formula outlined in the regulations, it is clear that residential properties would be especially vulnerable. They are, on the whole, not likely to generate much in the way of current use value. More significantly, the effective 50% discount granted the state in the event of a property seizure is a potentially crippling blow for homeowners. A home represents not just a shelter, but a sense of belonging and dignity. And in pure financial terms, it is also the largest investment most of us are ever likely to make. This is ever more the case the lower down the socio-economic scale people find themselves. A modest home may be the only asset a less affluent household owns. To expropriate under the conditions set out in the regulations is to threaten the financial security and retirement planning, both being perpetually tenuous in today's hard-scrabble economy, of any number of ordinary South Africans, particularly and disproportionately the country's poorer people. The regulations also serve to warn those who might be tempted to believe that, however concerning EWC is, it will be somebody else's problem, perhaps an issue for farmers to deal with. The broadened powers and discretion, the tipping of the relationship between the individual and the state decisively in favour of the state, makes this an issue that none of us dares ignore. Now, the issue that they don't raise here is that the banks would be aware of this. Yeah, your banks in South Africa would know all about this change in the regulations. And that's why, if you need a loan on your property, they're going to take this into consideration. So it's going to be very, very hard to get a loan to buy a property in South Africa. And it's no surprise then that what I'm hearing is that land and residential prices have dropped by something like 40% since the expropriation of land without compensation came into effect late last year. This is absolutely crazy. Anyway, guys, have a good evening, and please remember to subscribe to be kept informed, and take care.